In the spirit of today's show, I should refuse to even say what I'm saying right now, because we're doing a show on the Fifth Amendment, which actually pertains, one clause of it pertains to your right against self-incrimination. So where does that right come from? Why did the framers put it in? How does it get used these days? Is there a stigma attached to it? We certainly have seen that recently when people tried to attach a stigma to it when Dr. Anthony Fauci invoked it. We'll talk about all those things and more. The idea of the Fifth Amendment is coming up. Take the Fifth, indeed. Today we are talking about pleading the Fifth, taking the Fifth, invoking your right against self-incrimination under one clause of the Fifth Amendment of the U.S. Constitution. It was very much in the news last week. We will remind you how and why that was in just a second. And a little bit later in the show, you're going to hear from a former defense attorney turned law professor who believes you should never, ever say anything to the police. Under any circumstances. You can make a pretty solid case for that, too. Towards the end of the show, we'll talk about how the Fifth Amendment was used by defendants or people who didn't want to become defendants during the McCarthy era and what Joe McCarthy did with that. But to begin, we're going to talk to someone who doesn't need the Fifth Amendment because he's a sterling professor of law and political science at Yale University. If you're a sterling professor of law, you can do anything. You can kill people. Nobody can do anything about it. Not that he ever would. He's a wonderful gentleman. Akil Reed Amar, who's been on our show many times. Sterling professor of law, as I said, and political science at Yale University. His latest book is Born Equal, Remaking America's Constitution, 1840 to 1920, which was a winner of the annual Abraham Lincoln Institute Book Prize. We are proud and pleased to have him back with us. Akil Reed Amar, welcome back to our show.
Thanks for having me again, pal.
So, explain, no, the Fifth Amendment is a bigger animal, obviously, than just the self-incrimination clause. Do we want to just talk about that clause itself?
Yeah.
Yes. Okay, go ahead.
It actually doesn't overlap that much with the other stuff in the Fifth Amendment.
So say a little bit about why it's there. I know that one argument you may make is that nobody really entirely knows why it's there, but theoretically, why do we have that?
Well, these words that no person shall be compelled to be a witness against himself in any criminal case. These words and variants of them go back for centuries, and they and across continents, and they've meant different things at different times. So it's kind of keeps morphing in its meaning and purpose. I'll just give you an example. This phrase originally comes from canon law. There's a fancy Latin phrase, but I don't speak Latin. But the idea in early canon law, suppose you're actually an early Christian. It's before the conversion of Constantine. It's 300 AD. And confession is actually a sacrament. You're supposed to confess things to your confessor. Marriage is a sacrament. There are other sacraments. Oh, but they don't want you to confess to the authorities because in the Roman Empire, before the conversion of Constantine, they don't like Christians. They worship, a false god, according to the Romans. And so if actually you were to confess that you were Christian, that's a death sentence. But today we don't need the Fifth Amendment in America for that because we have a First Amendment that says that you have a right to be a Christian or not to be a Christian, and they can't put you to death or criminally punish you, no matter which thing you choose. Now, I'm going to flash forward 1,000 years move over maybe 1,000 miles from, or approximately from Rome or the Holy Land over to England. So listen, it's now 1600 in England, and criminal defendants don't have actually counsel. And so if you just get up and say, in your trial, I don't want to speak, the judge will say, well, be my guest. You're slitting your own throat, because if you don't speak, no one else will. Who's going to conduct your defense? So,
and we should say that if that sounds familiar to people, you're talking, I think, about the Star Chamber, although there were also ecclesiastical courts at that time. We're talking about kind of the Henry II period, where, in fact,
from Henry II all the way through Henry VIII and beyond. People don't really get lawyers until, in serious cases, until the Treason Trials Act of like 1696 or something like that. So in a world without lawyers, Fifth Amendment, the right to remain silent, is going to have completely different implications than in a world with lawyers, where you have your lawyer do the talking and you stay mum. It's going to mean something completely different when you don't have something like the First Amendment protecting your right to have political views or religious views than when you do have such a thing. So then the question becomes, Colin, why do we have it today? And the truth is, most scholars don't even quite agree. Courts say certain things, but I'm not sure they actually make sense. Here's what they say, the courts in general. There's a cruel trilemma. If you can be forced to talk, here's the problem. If you don't talk, they punish you for remaining silent. And if you do talk and lie, they prosecute you for perjury. And if you talk and tell the truth, you've just slit your own throat because you confessed to the crime and they didn't have the evidence otherwise. And they call that a cruel trilemma. Door number 1, 2, 3, all bad boxes. You're punished, all bad doors. You're punished for silence. You're punished if you speak and lie, and you're punished if you speak and tell the truth and give them evidence. But it's only a trilemma if you did it. If you're innocent, the argument goes, you could take the stand and just say, I'm innocent, and there's no trilemma at all. And what's cruel?
Although, let me just pause here and say, this doesn't always involve taking the stand. And let me give you an example. Let's do a hypothetical. Let's say that you, on some given night, are driving down a secondary road somewhere in the greater New Haven area, and suddenly a cop pulls you over. And in the amount of time it takes the cop to walk over to your car and ask for your license and registration, you realize, you're probably going maybe close to 50 miles an hour, and you can see a sign now that says 35. So the first thing the cop asks you typically is, do you know how fast you were going, sir? What's your answer?
So you're just getting a wee bit ahead of me. Let me just sort of finish the thought and then tell you how we move from a courtroom to your automobile. Okay. But if you were innocent, your mom didn't teach you that when you're guilty, don't confess or something like that. So is this only about protecting the guilty? If so, it's not as great an amendment if it's about protecting innocent people. Now, the first question, Colin, is how did we get from, in any criminal case, no person shall be compelled to be a witness against himself, to the car? The car isn't a criminal case at all. Okay. How did we get to testifying in front of Congress? Here's how. So here's my theory about why we have it. We have it because you might be innocent, but maybe actually you sweat, you stutter. On the stand, some clever prosecutor is going to slice and dice you and make you look guilty, even though you're pure as the driven snow. That's why we have it, to protect innocent people from being erroneously convicted. Now, if that's so, now just give me 1 minute and I'll get to the car.
Okay.
Then they can't force me to take the stand, because maybe I sweat, maybe I stutter. The jury's going to think, I don't look so hot, and the jury's going to think I'm a guilty so-and-so, even though I'm not. Fine. So the clever prosecutor says, oh, I'm not going to put you on the stand. I'm going to walk across the street, and we'll take the jury with us. And I'm going to ask you all these questions across the street, and then we're going to walk back. And you say, no, same thing. Oh, the prosecutor says, oh, I'm going to walk across the street with Amar, and I'm going to videotape him, and he's going to be under oath, and I'm going to ask the same questions, and he's going to still sweat and stutter. And then I'm going to introduce the videotape in the criminal prosecution. Well, same thing. Now, so what he says, oh, I'm going to do the video exercise before I indict him, before I charge him. But again, I'm going to do it in the police station. Same problem. Oh, now I'm going to do it in the vehicle. Okay. But same problem. Again, imagine they had a webcam or something like that. But they don't have to. If I say anything at all, they can repeat in my criminal case what I said, and maybe I stutter, and they can report that I was sweating like a pig or something like that. So, and that's true if they try to force me to testify before Congress as well. So this right is actually a courtroom right. It's in any criminal case. No person shall be compelled to be a witness against himself. In order to protect that courtroom right, we have to allow people to take the fifth in all sorts of situations, in their vehicle, in Congress, if they're asked to testify in someone else's civil case or what have you.
Okay, let's go back to my example. You're dimly aware you might have been going 50, posted 35, officer asks you, do you know how fast you were going? What do you say?
Well, because I'm law trained, I might not say anything at all. I think your future guest is going to say you're often well advised to just shut your trap, unless your lawyer is present and advising you. But Colin, let's take your hypothetical. Here's what the cop can do. He can make me go out of the car. Mm-hmm. He can make me blow into a balloon. And if I don't, that can be held against me. He can actually, at a certain point, take me to the station and make me stick out my arm. And he can stick a needle in it, take my very blood, my very self, and this is permitted, and I think it's okay, and I'll tell you why, and use that blood to prove, maybe not that I was doing 50, but that I actually, my blood alcohol level was over the limit. Or maybe he can use that blood to prove with ABDO blood testing or DNA testing that I match blood at a crime scene, okay? So, and that's permissible. So the question is, why can cops actually, take your blood? Why can they force you to stand up in a lineup or show up and do other things, but not put you on the stand?
I think the answer is that they can legally collect evidence. They can't compel you to say stuff that might incriminate you. I mean, I think that's how they would answer.
Yeah, but what does that mean? Collect evidence, okay? Can they, Colin? Can they force me in the lineup? Let's say it's a bank robbery, and they have the bank teller. Can they force me to utter the words, stick them up, because that's what the guy said in the bank? The answer is yes, they actually can. Can they force me to give a voice exemplar? If it's a ransom situation and there was a phone call that they recorded from the kidnappers, and can they match my voice exemplar against the ransom? Yes, they can actually. So the question is, what counts as forcing me to produce evidence, which you say is okay, versus forcing me to be a witness against myself, which isn't okay.
All right. I didn't say it was okay, by the way.
A handwriting sample.
I said the cops would probably say that it was okay. All right, let's go to the thing that's occasioning all this, and that would have been last week on July 29th. Anthony Fauci is in front of the Homeland Security and Government Affairs Committee, and he says the following. He says something like this kind of multiple times. A1, please.
Although it pains me to do so, because of the respect I have for the legislative branch of government and my decades-long record of cooperating with Congress, under the advice of my attorneys, I will invoke my right under the Fifth Amendment of the Constitution to refrain from answering your questions.
Okay, tell me what you hear here.
So, it's being videotaped. If he didn't do that, if he answered, prosecutors in some later case could use that videotape, and maybe he's sweating and stuttering and doing all sorts of things. So we have the same problem that we had that I was describing. So he's allowed to take the fifth. Now you say, well, Congress needs information. There's a way that Congress can get the information and still respect his rights. It's called immunity. And if we give him the right kind of immunity, we being the Senate of the United States, then he can be obliged to answer all the questions.
But they're not going to do that because we know, and this is an interesting thing here, we know they have an a priori goal. They've already said that. Rand Paul and others have said their goal is to get him behind bars. This is something that a typical court will not do, is to say, oh, good afternoon, Mr. Defendant. We should tell you our goal is to put you behind bars. The prosecutor might say that. The court wouldn't. This is one of the reasons that Senate committees are sometimes used, because the due process isn't really at the same level. So they're not going to give you immunity because they've already decided they're not on a fact-finding mission. They want to put him behind bars.
And Rand Paul calls himself a libertarian, opposed to big government that bullies people. Well, that's what he's doing. If he wants to put people behind bars, that's what big government does. And sometimes we have to, because people murder and rape and rob. But if they want the information, all they have to do is give him immunity. Now, the question is exactly what kind of immunity they have to give him. And here, actually, experts disagree. But Congress all the time in the past immunizes witnesses. Your audience may remember that Oliver North, way back when, remember that name, Oliver North, Iran-Contra? He was hauled before Congress. He took the Fifth, and he actually was made to speak in front of committees like this one because he was given a certain immunity for his testimony, and he was obliged to testify. Right.
So, what about this whole argument that is getting made that because he has a pardon from Joe Biden, it's a pretty, they're calling it a blanket pardon. Because he has that, he can't, it was argued by Josh Hawley and others, he can't invoke the Fifth Amendment because he's not in any danger.
Now, cards on the table. Josh Hawley is my former student. Okay. He's thanked in a book that I wrote on the Constitution. He's thanked by name. I wrote his clerkship letter of recommendation, and I'd remind my friend Josh of what I tried to teach all my students back in the day, okay? Because that argument is not a good argument. So some of your audience, you're married couples, okay? And someone hogs the blanket. Okay, you said he has a blanket pardon. Well, when someone hogs that blanket, the other person doesn't have the blanket. It's not a blanket pardon because it only covers possible offenses up through the day the pardon issued, which was at the end of the Biden administration. But he might be on the hook for claims, at least, that after the end of the Biden administration, he continued to do things that might be criminally punishable. And some of those things are maybe even inactions and silences. He can be claimed, well, you're covering up things, and that's an ongoing crime. And every day that you continue a cover up under President Trump, that's an additional crime. Perhaps it would depend on the relevant statutes. And the Biden pardon does not avail you at all because people are not allowed to pardon for offenses that have not yet occurred. They can only pardon for past offenses, and President Biden's pardon extended only to things that had happened, crimes up to that date.
He's also now, it has been announced by the states of Florida, Louisiana, and Alabama, I think, that they are initiating investigations. I assume the pardon doesn't give him protection from a state investigation if it's a federal pardon.
That's another complex area. I wrote an article in the Columbia Law Review about that. It's called, the dual sovereignty issue. It's connected also, can one government grab evidence illegally and give it to another government on, quote, a silver platter, or does the exclusionary rule apply when one government actually shares evidence with another? If you've been convicted in a federal case, can you be prosecuted under state law or not, and vice versa? And that's, double jeopardy issues that are raised by the so-called dual sovereignty doctrine. So there are all sorts of complexities here, but the short answer to your question is, under existing doctrine, it's pretty clear that Joe Biden's pardon does not immunize Fauci for any possible state criminal prosecution. So right. Another good point.
We have to stop there. Akil Reed Amar, I know you have lots more to say. We have 49 minutes. Sterling, a professor of law and political science at Yale University. His latest book is Born Equal, Remaking America's Constitution, 1840 to 1920. We'll take a break. We're going to talk to a man who has been described as the Johnny Appleseed of the Fifth Amendment. I would say that those apples would have to be highly caffeinated for him to have anything to do with them.
You say it best when you say nothing at all.
don't see. You got to hear and don't hear. You got to know and don't know. And don't tell everybody where you go. 'Cause it's a miracle so far. We haven't got caught, and I intend to keep it that way. Because it's better to say there he go than to say there he lay. You know that, baby. Ooh, you got to take the Fifth Amendment. Take this book home and learn the Fifth Amendment. You got to take the Fifth Amendment and refuse to answer on the grounds it might tend to incriminate you and me. Listen, baby, let me say something else right here.
And our next guest, if he were striding up to the plate about to hit a home run, that could be his walk-up music. James Duane teaches at Regent Law School. He is the author of You Have the Right to Remain Innocent, What Police Officers Tell Their Children About the Fifth Amendment. His YouTube video, Don't Talk to the Police, has over 21 million views. We are very excited to have him here today. James Duane, welcome to our conversation.
Thank you. It's my pleasure to join you.
So, maybe we should just begin by articulating your basic position. Your basic position, I think, has already been suggested by my introduction to you, which is people are very, very unwise if they talk to the police about anything in almost any situation. Is that fair?
That's a pretty fair statement, yes. And not just the police, I might add. It's just about anybody who works for the government, any government agency. But particularly the police, because investigative agents like folks from the FBI or the police department are the ones who are most likely to reach out to you and try to initiate a conversation that was not your idea.
Yeah, so sometimes I gave the example, I think you hadn't joined us yet. I was talking to Akil Amar about this, and I said, what if a cop pulls you over and you realize in the time it takes him to ask for your ID and your registration that you're maybe going about 50 miles an hour and it's a 35-mile-an-hour zone, and the first thing the cop asks you is, do you know how fast you were going? So what should you do in that situation?
Well, that's a slightly different situation, as I explained in the book. The book is primarily, I'll answer your question in just a second. The main point behind the book is how to handle unexpected, unscheduled, unsolicited encounters with investigative agents who drop in your house or drop by the office and want to ask you some questions about some situation that they're investigating. But a traffic stop is entirely different for a couple of different reasons. Primarily because they have almost unlimited discretion to decide whether to write you a ticket or arrest you or let you go with a warning if they think you're suitably repentant and respectful. Obviously, that's not going to be true in the case of a murder investigation. If they think you may be guilty of a murder or a torture or kidnapping, they're not going to let you go because you seem to be sorry for what you've done. So you want to be cooperative in the course of a traffic stop. You want to talk to them and you want to come across as respectful. However, if they ask you, do you know how fast you were going? The answer is always the same. You say, no, officer, I'm sorry, I don't. Which is the truth, by the way, because you don't know if you're going 55.72 miles an hour or 55.73. Mm-hmm. You don't know your exact speed. Far too many idiots make the mistake of thinking, I'm going to argue with the police. I'll insist, oh, no, I know I was going under the speed limit. I had the cruise control on it. They hear people tell them this lie all day long, and almost all of them are lying, and they're sick and they're fed up with it. And if you talk to the police, he's already got his mind made up. I don't know if it was based on the radar gun or some other observations. He's already made up his mind as what he's going to tell the judge as to how fast he knows you were going. You cannot talk him out of it.
Well, I saw the presentation that you did with a third-year law student who was also a working member of the Virginia Police Department. And he said an interesting thing, and he described something that I have done. Okay, so I'm in that situation. Maybe maybe I'm going 50. Maybe I was going 50, 35-mile-an-hour zone. The cop asked me that question. And to seem reasonable, I think I might have said, I don't know, I'm maybe 38, 39 miles an hour, something like that. Because you don't want to seem like you're just in total denial about it. And I feel like if I say I don't know how fast I was going, am I not supposed to know how fast I'm going? Isn't that sort of part of the deal being a driver, that you know how fast you're going? So, well, but that's not. Yes, but your friend there, the cop, he said, don't do that, right? Don't say, oh, it might have been 39.
Right. Let me finish. I apologize. You don't want to say, I have no idea, officer. I'm totally ignorant. I absolutely could believe you said it might have been 100 miles an hour. Of course not. What you want to tell the officer is, to the best of my knowledge, I think I was going under the speed limit, but perhaps I was mistaken. And if I was mistaken, I appreciate you bringing it to my attention, because I pride myself on my pristine driving record, and I don't want to be violating the rules without, inadvertently and unintentionally. I said that a number of times to police officers who pulled me over for speeding, and every time they let me go with a warning and said, well, don't do it again. And that's why I've never been convicted of a speeding, because I seem like I'm suitably repentant and respectful. But if you argue with them and you say, "Oh no, officer, you must be mistaken. You must have been pointing the radar gun at somebody else," they're going to think you need to be taught a lesson.
Okay, so let's get away from traffic. Let's get away from traffic stops, because they are, as you suggest, their own thing in a way.
Sure.
So
Yes.
most of the other things that you write about, the things that you teach about, have to do more with, it could be a thing where I got a call from the IRS. Hey, Colin, we'd like to come and talk to you about a couple of your returns here. Or it could be, pretty conventional situations like the one that I don't know if it's a conventional situation, that Dr. Anthony Fauci found himself in last week, where he repeatedly, over and over again, invoked his Fifth Amendment rights.
Yes.
Maybe we can begin by talking about that. Was it necessary for him every time to say, in fact, we can even give you kind of an example of how pervasive that got. Here's a clip. It's an exchange between him and Senator Josh Hawley. This would be B2, sir.
Well, nothing says honesty like taking the Fifth, huh, Doc? Let's try something. What day of the week is it today?
On the advice of counsel, I respectfully decline to answer based upon my rights under the Fifth Amendment to the Constitution.
What color tie are you wearing?
On the advice of counsel, I respectfully decline to answer based upon my rights under the Fifth Amendment to the Constitution.
What color's the carpet in front of you?
On the advice of counsel, I respectfully decline to answer based upon my rights under the Fifth Amendment to the Constitution.
Let's just get one thing straight. You don't have any rights under the Fifth Amendment because you've been pardoned, as you very well know. As the Supreme Court has been clear for a century and more, Brown versus Walker, 1896, when he has been pardoned, he may not stand upon his privilege. You know that. Your lawyers sitting behind you now shifting nervously in their chairs. They know it. This isn't about the Constitution. This isn't about the law. This is about contempt. Contempt for this body and contempt for the American people.
Okay, so there's a lot there for you to unpack. But could we just start with the first thing, where Fauci kind of almost ritualistically has to say the same thing in answer to every single question? First of all, is that common? Is that the way that you, quote unquote, have to do it?
That's an excellent and an important question. The short answer is no. It is not necessary, strictly speaking. If you're worried about the possibility, if you're representing Anthony Fauci, or you're Anthony Fauci answering a bunch of questions and you're worried about possibly incriminating yourself, strictly speaking, no. Under the Constitution and under the Fifth Amendment, as the Supreme Court has interpreted it, it is not necessary for him to say, "I'm not going to answer questions about the color of my tie." And with good reason, there was audible laughter in the room when he gave those ridiculous assertions that he couldn't answer questions about the color of the tie. There was another point when he said he wouldn't answer a question whether a folder was in front of him based upon the Fifth Amendment, because the Supreme Court has made it clear that in the context of an investigatory setting, like a testimony before a Senate committee or a grand jury, a witness is allowed to say, "Well, I'll answer this question, but not this one. And now I'm going to assert the Fifth on this one, but I'll answer this one." You could do it selectively. However, that's the short answer. Don't forget, back in 2014, when Lois Lerner testified, she was called to testify before a House subcommittee in the Congress about her possible involvement in some constitutional violations while she was a high-ranking officer in the Internal Revenue Service. Remember what happened? She came in a short statement where she said, "I didn't do anything, and now I'm leaving." And Trey Gowdy, at the time, who was a Republican congressman from South Carolina, he reprimanded her. He lectured her, and he said, "You can't do that. You can't come in and you can't say anything at all." And then try to invoke the Fifth Amendment. And noted Harvard law professor Alan Dershowitz shortly afterwards chimed in and agreed incredibly. Thank God Dershowitz was wrong about that, but Dershowitz himself said in writing that the Supreme Court has made it very clear that you cannot turn the Fifth Amendment on and off like a spigot. Once you open it, in for a penny, in for a pound. If you answer any questions at all, even if all you say, as Lois Lerner did, was that I haven't committed any crime, then you've waived your Fifth Amendment privilege. So I can't blame people like Anthony Fauci's lawyer for coming to the conclusion, look, even though Dershowitz was wrong and Trey Gowdy was absolutely wrong about this, they are representative of people who honestly believe this nonsense. And if you therefore answer any questions, even a couple of questions about the color of your tie, we're going to run the risk that some of these Republicans might actually move to hold you in contempt based upon the theory that you've waived your Fifth Amendment privilege because you've answered any questions at all. And that's the same advice, I might add, that I would certainly give my client if, like Fauci's lawyer, I had just been told by Rand Paul, you've got to get out of the room. We're not going to let you sit here and advise your client as he decides whether to invoke the Fifth Amendment privilege on each individual question. I would say, look, you got to just invoke the Fifth on everything.
Mm-hmm. Yes.
That's so, what I'd have to advise him.
You probably also want to say something about Holly's eventual. Well, I should say that on social media later, Holly actually wrote, "No honest person pleads the Fifth." Apparently, having forgotten that Donald Trump pled the Fifth or invoked his Fifth Amendment rights, I think 450 times in the New York AG case. Eric Trump Jr., Jeffrey Clark, Roger Stone, John Eastman, all these people have used the Fifth Amendment exactly the same way. But that is a prejudice that is brought up a lot, right? No honest person would be doing it. It was said by a lot of people who were critiquing Fauci. What's your response to that?
Oh, it's emphatically false, and I'm glad you asked. In fact, it's the central point of the book, and the central point behind my motivation in writing the book is to try to help average Americans, to understand that the Fifth Amendment, as the U.S. Supreme Court, by the way, has repeatedly explained and held, was written not just for guilty people, but also for the protection of innocent people like you and me who might be ensnared by ambiguous circumstances. And that's why Josh Hawley, with all due respect to him, I mean, he's a very sensible man, generally speaking, but brilliant man, quite frankly. But he couldn't have been more wrong when he proclaimed just a couple of nights ago on the Sean Hannity show that innocent people don't take the Fifth. That's absolutely false. The Supreme Court's repeatedly said that it is false. I'd like to take this opportunity right now to publicly challenge Senator Hawley to a debate on that topic. Anywhere he would like, anytime, any place. We can do it in front of the U.S. Senate. He could pick the judge of the debate, and he will lose that debate. He will be crushed in that debate because it's absolutely false. And like you said, ironically, President Trump, years ago, back in around 2016, he also, in a similar vein, you may recall, when Hillary Clinton, some of her top aides and employees were being questioned about their role in her in the creation and the maintenance of her private server, they took the Fifth. And Donald Trump publicly announced, well, that proves that she's guilty because the people who worked for her had taken the Fifth. And that's something that only the mob does, which is
okay. Allow me to jump in here. This is President Trump saying something very, very different under, I think, the circumstances I mentioned before. This is B3, please.
Anyone in my position not taking the Fifth Amendment would be a fool, an absolute fool. One statement or answer that is ever so slightly off, just ever so slightly, by accident, by mistake, such as it was a sunny and beautiful day when actually it was slightly overcast, would be met by law enforcement at a level seldom seen in this country, because I've experienced it.
James, he read your book.
Thank God. A little vague, yes. But there's the irony. When the shoe was on the other foot, and it was Hillary and her aides who were invoking the Fifth, he publicly denounced them and said this was powerful evidence of their guilt and their criminality, because that's the sort of thing that only the mob does. But when the tables are turned and he's now the subject of investigative inquiries, all of a sudden now he's a passionate admirer of the sublime beauty of the Fifth Amendment.
Well, not only that, but I mean, I think his answer, I don't say this about President Trump very often, but it's kind of subtle, and it really is James Duane-esque in the sense that, I mean, I've heard you talk about it, you could say something like, oh, I couldn't have robbed a bank in Virginia Beach because I was at the Outer Banks that night, and then the cops find somebody who think they saw you in Virginia Beach, and suddenly evidence is mounting up, even if you were in the Outer Banks, even if you weren't there. Suddenly, because you have engaged in that way, you're building a little ladder that they can begin to climb up. I think that's sort of what Trump is saying there, too.
Exactly. That's right. Yes, sure. Yeah. I mean, the book that I wrote, again, it's called, you said, The Right to Remain Innocent. It's actually chock full of real-world anecdotes, horror stories, from the pages of the law library of innocent people later exonerated after 10, 20, 30 years by DNA evidence after they were in prison for 30 years. And I show in the book how so many of them were convicted on the basis of truthful information that they voluntarily agreed to supply to the police. I mean, one example in the book was the case of Michael Morton, who spent 20 years of a life sentence in a Texas prison before he was exonerated. And one of the key pieces of evidence against him, allegedly, was the fact that he had agreed to answer questions from the police about what night he and his wife had dinner together the night before somebody broke into their house and murdered her while he was gone. You'd be likely to think, well, how could that be harmful? How could that be a dangerous question? That sounds like a safe question. All they want to know is what time we had dinner together. But by itself, that would seem to be totally innocuous, especially if you know that you're innocent. And God bless him, the poor fool. He took the bait. He answered to the question. And at trial, the prosecutor brought in an expert who said that based upon his examination of the contents of the victim's stomach, he was able to ascertain, he thought, that by his own admission, the dinner was so many hours before the murder, and that would mean that the murder therefore must have taken place at a time when Michael Morton had already admitted he was still alone with his wife in the house. So he allegedly incriminated himself. This man that we now know to be innocent, supposedly, according to this expert testimony, merely by virtue of the fact that he agreed to answer a question about what time he had dinner the night before.
So why does the Fifth Amendment have such a poor reputation? I mean, it's a right. It's a right that's spelled out in the Constitution. It's a right like lots of other rights that we're pretty comfortable invoking. Is it because we've watched too many mob movies and gangster movies? Or how have we gotten it into our head that there's anything wrong with using it?
It's a fair question. The Supreme Court has repeatedly said for the past 100 years, the court has said that far too many people, even those who ought to be better advised, mistakenly assume that if you're refusing to answer a question on the grounds that it will incriminate you, that's an all but unambiguous confession that the truth would, in fact, prove that you are guilty. But it's not that simple. It means that there's a possibility that the answer to these questions might tend to incriminate me by convicting me, perhaps, of a crime I did not commit. That's also an equally viable basis for the assertion of the Fifth Amendment privilege. And by the way, part of the problem is that for far too long, criminal defendants and other suspects, when being interrogated, on the advice of the attorney, they say, I respectfully decline to answer on the grounds that an answer may tend to incriminate me. And, the word incriminate it comes from the same Latin root as crime and criminal. It sounds like you're essentially admitting that the truth would prove that I'm guilty, which is not what you're saying. You're merely advising them of the position that I'm worried here that I may find myself in a situation where the truth could possibly convict me of a crime that I didn't commit. But that's not well understood, not widely enough today. And that's exactly why we have the problem that you described a moment ago.
I wonder if also people make the mistake of thinking there's some kind of demarcation between what the police like to call, as I learned from the presentation that you co-hosted, an interview, not an interrogation, an interview. That the interview is one thing, and then maybe when you get to court, that's another thing. I don't think Miranda decision notwithstanding, I think a lot of people think, in an interview, I probably shouldn't be taking the Fifth. That's for court. And I should just be cooperative with the police who seem very nice right now.
Exactly. But as I explained in the book, we've been talking a lot about Fauci and his testimony on the record before the Senate and before Rand Paul. The potential perils and the complications are multiplied infinitely. And when you find yourself in an informal interrogation or an interview with a police officer that may or may not be getting recorded, because the Supreme Court and the lower courts in recent decades have made it painfully clear that the police can lie to you about almost everything and exactly what you are or are not up against. There are countless cases where the police officer says, don't worry, you're not a suspect. We know you weren't involved. We're not going to arrest you. We're not going to come after you. And every bit of it is a lie. And the officer later admits under oath, it was all a lie. I was trying to get his guard down. I was trying to lull him into a false sense of security, a false sense of complacency. Sometimes the police will even lie to you and say, we know the other guys were doing the ones we know you were just there as a witness. You're on our side. We want to use you as a witness against the others. When in fact, that is not their intention. They're just, again, trying to lie to you in an effort to try to persuade you that it may be in your best interest to cooperate them and to be part of our team. In one recent case up in New York, federal agents told a criminal suspect, we're not going to come after you. They promised him. And they said, we want you to put on our jersey, Team USA. You're going to be a witness for the prosecution. The poor fool, you can't blame him. He was taught by his parents at a young age, you can always trust the police. He didn't know that it was emphatically, absolutely false. He believed it. They broke all their promises. He was prosecuted. He was indicted. And the U.S. Court of Appeals said, we don't have a problem with that. Good job, officer. Well done. You can't believe what you're being told by the police.
All right, we have to stop there, although I do want to say that James Duane would like you to learn the words, I want a lawyer, for 99% of the kinds of situations we're talking about. James Duane teaches at Regent Law School. He's the author of You Have the Right to Remain Innocent, What Police Officers Tell Their Children About the Fifth Amendment. His YouTube video, Don't Talk to the Police, has over 21 million views. We will take a break. We'll come back. We'll talk about a fairly ignominious use of this in fairly recent history.
Send lawyers, guns, and money. Hey! Send lawyers, guns, and money. Oh! Yeah.
And today's show, our technical producer is Dylan Reyes, a 3,200-year-old Sumerian minor divinity, and also our technical producer. Lily Tyson definitely did not shoot a man in Colebrook, Connecticut, just to watch him die. She is the head of Lily Tyson Quality Entertainment Productions. She hasn't done anything that any police officer should ask her any questions about, and now she knows what to say anyway. All right. So one of the things I thought about as we were getting ready for this show was the Fifth Amendment during the time of McCarthyism, and we've already interviewed this guest before for his excellent book, Red Scare, Blacklist, McCarthyism and the Making of Modern America. Clay Risen is a reporter and editor at the New York Times. Clay Risen's back here with us to talk about the Fifth Amendment and the role that it played during the so-called Red Scare or McCarthyism. So first of all, welcome back, Clay Risen.
Oh, thanks for having me back. It's a pleasure.
And the number of people who invoked Fifth Amendment rights, particularly I think in front of that permanent select committee, was large. I think for one of the committees alone, I think 106 people invoked the Fifth Amendment. So why was that happening? Why was that happening as McCarthy tried to root out communists?
Well, first of all, people long before even McCarthy came along, when it was largely the House Un-American Activities Committee, when this started with the Hollywood trials or the Hollywood hearings, people tried to take the First Amendment. They said, look, I don't have to say, you can't force me to speak. And that largely failed. Courts, it was tested in courts, and they said, no, actually, you are compelled to speak in front of Congress. So then lawyers started saying, well, look, take the Fifth. You can't say anything to incriminate yourself. And so that became kind of the de rigueur of these hearings, whether it was in front of HUAC or in front of McCarthy or the Senate select subcommittee on domestic security. This was widespread. Hundreds of witnesses over the course of the Red Scare took the Fifth.
And they sometimes tried to kind of finesse it a little bit. I think Lillian Hellman tried unsuccessfully to have HUAC allow her to talk about herself, but not about anybody else. Other witnesses tried to avoid naming names. Some took what came to be called the diminished fifth and denied president involvement with the Communist Party, but invoked their privilege relative to past events. How did any of that work out for them?
Well, by the middle of the 50s, Congress largely let people take the Fifth. They kind of didn't get involved in the legal niceties of the diminished Fifth, because ultimately what was happening was really not about getting information. Congress had many ways to get information. They had there were investigators. There was state level investigations, and really what was happening was a kind of degradation ceremony. The idea was, let's get people in front of Congress, in front of reporters, in front of the public, and make them take the Fifth. And then we will tell everyone that no innocent person takes the Fifth. And that the implication is, when we ask, are you or have you ever been a member of the Communist Party? And they say, I won't talk to you, I'm going to take the Fifth Amendment. Then that's essentially an admission of guilt. And the consequences were not meted out in Congress, they were meted out in the public. If they were a public figure, they were attacked viciously. If they were private citizens, they could lose their jobs, they could find themselves unable to get bank loans. If you were a teacher in New York, it was understood, as well as other places, it was understood that if you didn't cooperate with Congress, if you did take the Fifth, you would be fired. And that happened to hundreds of people.
You might want to even give the example of Mildred Flax, a substitute elementary teacher who lived in Bed-Stuy. Explain what happened to somebody like her.
Yeah, so the school board in New York had a standing rule that if you don't cooperate with the federal government, if you come down to Washington and you say, I refuse to talk about my past, I'm not going to talk about people I work with, then you were considered unfit for teaching children and you would be fired. And that happened to, many folks, even folks who wanted to cooperate but didn't want to deal with the implications. McCarthy was someone that clearly was a bad actor. He was not looking for the truth. And so, it was understandable that people wanted nothing to do with him. And yet the consequence of taking a stand was the destruction of a person's livelihood.
Yeah, and I do want to say that I'll say it. You don't have to say it. I don't want to get you in trouble. But I mean, one of the things that I felt watching those hearings last week with Fauci is they had an a priori goal, and it was not to get more information about this. It was to pin something on Tony Fauci. They said that essentially that was their goal. So and then I read a quote from McCarthy that sounded exact as you've already kind of referenced this, but he said a witness's refusal to answer whether or not he is a communist on the ground that his answer would tend to incriminate him is the most positive proof obtainable that the witness is a communist. Somehow or other, this rope got played out to a point where it didn't work as well anymore. And at a certain point, people felt a little bit more comfortable invoking their Fifth Amendment rights and maybe not having to face horrible consequences. Was there just kind of a weather change about McCarthy and his obvious fraudulence?
Yeah, there was. And it was largely McCarthy. I mean, when he was sort of debased in 1954 and knocked off his pedestal, that didn't end the Red Scare, but it did signal a shift. The willingness of people like Joseph Welch, the lawyer who stood up and said, "Have you no sense of decency?" Edward R. Murrow, some of his colleagues in Congress, some of his fellow Republicans, who stood up to him, kind of broke the fever of the Red Scare and showed that you could take a stand and not face horrible consequences. That hadn't been true before. People had taken stands and they had gone to jail. And so here were examples of people who didn't do that. And so you started to see more people, taking the Fifth and not facing consequences, and then starting to speak and starting to say, well, look, I will talk about my past, in guarded ways, certainly in ways that did not incriminate other people, but being willing to go a little further. And I think that that's so much of what it's very hard to put your finger on, well, what caused this change. But I think the public got tired of the mudslinging and the personal attacks and just the idea that because someone doesn't want to talk to Congress, they're suddenly cast out of society.
As you were researching this book, this is probably our last question. Were you surprised by the willingness of professional organizations and major employers to kind of surrender and say, "Oh yes, the Fifth Amendment shouldn't be allowed"? The American Association of Universities issued a statement saying that the Fifth Amendment shouldn't be allowed in the hearings. Other professional organizations made it a litmus test as to whether you'd get hired for something or whether you could be in the organization. Did it surprise you? I mean, this is a right that's spelled out in the Constitution.
Yeah, I mean, look, I would say maybe I'm naive, but it did surprise me. And the extent to which it happened. And this is, I think, when people ask all the time, what are the parallels between then and now? I think the great parallel is just the lesson that even powerful people, even powerful institutions are willing to bend and cooperate with what they think is the mob. Right. So there's no reason why a law firm or a big university should bow down to the administration. They should take a stand. Right. But to them, the calculus is different. And the same thing happened back then. Look, my own employer, the New York Times, made it clear that if its employees were called down to Washington, they could not take the Fifth. And if they did, they would be disciplined. And that happened to many New York Times employees who were disciplined for taking the Fifth. Now, why did they do that? To hear their explanation, the management said, well, we don't want to fire you and we want to cooperate. We want to bend with the wind, not break. That was the kind of attitude. And unfortunately, that serves the interests of the ones who are leading the mob. And it's I think one of the most pernicious parts of any kind of mob is the calculus that leads people to follow.
All right. Well, Clay Rison, people should, if they haven't already, track down your book, Red Scare, Blacklists, McCarthyism, and the Making of Modern America. I think the last part of that title is very relevant to our conversation just now. Thank you for listening today. Go out, try to stay out of trouble. If you do get in trouble, don't tell the police anything.